2023 was an eventful year for the insolvency regime in India. The Supreme Court came out with a plethora of rulings that will go a long way in illuminating the insolvency domain with clarity. Let us now take a quick recap of the top 5 IBC rulings of this year. One of the biggest IBC developments came out in the latter part of the year. While dealing with a batch of petitions which dealt with the insolvency resolution process pertaining to individual firms and partnerships, the top court said that the provisions under challenge do not suffer from any manifest arbitrariness. The case dealt primarily with the role of resolution professionals in relation to personal guarantors. It was the contention of the petitioners that the resolution professionals exercise adjudicatory functions and therefore have unfettered powers under the IBC. However, the court was not inclined to accept this argument and said that a resolution professional does not in fact exercise any kind of adjudicatory functions in relation to personal guarantors. Now, as per the latest IBBI data, there are nearly 2,289 cases pending with the NCLT pertaining to personal guarantors. These involve a corporate debt to the tune of nearly 1.63 lakh crore, and the top court's ruling now paves the way for these cases to be taken up. Secondly, the court laid down the contours of preferential transactions under the IBC. Now, payments by a company that give unfair preference to one creditor over the other before the initiation of an insolvency proceeding are referred to as preferential transactions under the IBC. Providing clarity on how a preferential transaction must be viewed, the Apex Court clarified that a fraudulent intent isn't a prerequisite for a transaction to be classified as a preferential transaction. Further, it said that any transaction under any notice, demand, or threat will not lose its character as a preferential transaction merely on the basis of those alleged grounds. Whether a transaction was carried out voluntarily or not has nothing to do with it being classified as a preferential transaction. Coming to the next one, in a significant interim decision earlier this year, the top court permitted a first under the IBC by allowing a project-wise resolution for an insolvent real estate company. The top court was dealing with an insolvency plea against Supertech, the real estate giant. The top court said that if insolvency proceedings against Supertech were admitted as a whole, then it was likely to cause immense hardship to the buyers, home buyers. Another first, the top court refused to draw any kind of distinction amongst subclasses of home buyers. The court held that the provisions of IBC do not make any kind of distinction amongst different classes of financial creditors for the purposes of drawing up a resolution plan. Fourthly, in a decision that would put to rest the controversy behind the discretionary powers of the insolvency court to admit insolvency applications, the top court has said that once the NCLT is satisfied that a default pertaining to a financial debt has occurred, then it has no other option but to admit the insolvency application. Lastly, owing to certain conflicting rulings of the top court, the government's status as a secured creditor is now in a bind. A judgment came out last year which had cemented this position of the government being classified as a secured creditor. This stance attained finality this year when a batch of review petitions against this judgment were dismissed. However, there was another judgment which came out this year which said that dues payable to the government are placed much below those of secured creditor and even below those of the unsecured creditors and the operational creditors as well. Since both of these judgments were pronounced by a division bench, experts believe that this situation will now need to be authoritatively settled by a larger bench of the same court.